recently in Florida, there was what's passed, what we call tort reform, or the industry calls tort reform. And what it is generally speaking, it was pushed by the insurance companies, pushed by the Chamber of Commerce to, in their opinion, to change the laws in Florida. Governor DeSantis went at a press conference and announced, I'm going to change the whole laws in Florida, and I'm targeting billboard lawyers. As you may know, we're not billboard lawyers at Beers and Gordon, but it was targeting everyone. Most importantly, it was targeting you. That's what they don't tell you. The insurance companies don't tell you that. The Chamber of Commerce doesn't tell you that. And that's what's the worst part about this bill, is it targeted you as an individual. And frankly, they ignored that. So one of the things tort reform changed is for years, for I think it was 70 years, there was attorney fees that were paid if an insurance company did not properly pay a claim. If you could prove that an insurance company should have paid a claim, whether they shortchanged the amount of the claim, whether they denied the claim, and you prevailed, you got your attorney fees paid by that insurance company. The insurance companies fought against that even though the statute had been in place for more than 5 decades, they said, we're cutting that statute out completely. How does that affect you as a consumer? Let's talk about that. Let's say you have a water damage claim at your house. Floods, your toilet floods causes $15,000 of damage to your floor. You get an estimate that says it's $15,000, the insurance company says, well, we're going to pay you 10. In the old days, until March 24th, you could hire an attorney. That attorney would fight for that extra $5,000, and then they would get paid for their efforts, and the insurance company would have to pay for that. Now, it's going to be exceptionally difficult in this scenario where there's only like a few $1,000 difference between what the insurance company says they want to pay and what you have as the estimate. You're not going to be able to hire an attorney for a $3,000 claim or a $5,000 claim because you're going to have to pay by the hour. It used to be the insurance company, if you prevailed, they would pay those hourly fees. So it's going to be almost impossible in small cases to pay by the hour. And an attorney's not going to be able to take that case on a contingency basis. They're not going to be able to say, well, I'll take a third of the difference of $3,000, because the reality is they can't take a case through trial, through whatever the fight is, for $1,000. So it's going to make getting an attorney almost impossible. What do I think as an attorney, doing both sides, frankly, doing the defense side for 10 years and working for a company that I thought was one of the better insurance companies out there, and then being on this side? I think the long-term ramifications of this are going to be the insurance companies, knowing that they have very little risk, are going to start paying claims. If they save $1,000 or $2,000 on every claim because they know you're not going to fight it, and there's 100,000 claims in the state of Florida in a year, they save a lot of money. And that's what I think is going to be the long-term ramifications of this type of law with the attorney fee provision. How else does tort reform change Florida law? Until recently, the statute of limitations in Florida for a negligence claim was 4 years. They changed it to 2 years. The problem with that is now there's going to be more cases filed than ever. Between March 17th and March 24th, the statistics show more than 70,000 cases were filed in the state of Florida. How does that affect you if you're going to have a case in the future, or you have a currently pending case? The glut of cases is going to cause a gigantic problem. We noticed when we filed our first case in Seminole County and our last case in Seminole County, there was more cases filed in that 2-day period than it gets filed in 7 months. And we looked at that analysis because we could look at previous cases we had. So now you have a judicial system that was already overwhelmed, and the backup in that judicial system is going to cause cases to be delayed for years and years and years. Insurance companies, and I work for one, their goal is to delay the case and delay payment as long as possible. So that glut will delay the payment to you. If they know I'm not going to have to go to trial for 2.5 or 3 years, I'm going to hold on to that money. And the more the case is worth, the more they want to hold on to that money. I want to hold on to that money as long as possible, because the way insurance companies make money is they take the premium, they invest it, and they make money on that. So if they can hold that money back for as long as possible and wait, that's going to be the biggest effect of that glut in cases. Recently, there would be medical expenses. Medical expenses would be incurred by you. Now, after this tort reform bill, it's changed it to your medical expenses are capped at whatever the health insurance rate is if you have health insurance. Problem is, if you don't have health insurance, it's capped at 120% of Medicare. What's the problem with that? If you've never had a case, you may not know the problem. The problem with that is a lot of doctors are going to see you potentially without health insurance, but they can't afford to only get 120% of Medicare. Why? Because sometimes they're waiting 2 and 3 years to get paid. They may do a surgery in your case or in another case that someone may have that we represent, and they're waiting 2 or 3 years to pay the anesthesiologist, to pay the surgery center, and to pay the doctor himself. And that now they're saying, well, we're going to cap you on that 120%. What is the other problem that the legislature didn't anticipate on this? What happens when someone comes in from out of state? Florida is the #1 tourist state in the country. We have people driving in from all over the country. They get in an accident down in Florida. They go back to their state to treat. Florida law now says they're capped at 120% of Medicare. You know who's not capped at 120% of Medicare? Their doctors in North Carolina that they're treating with at the current time. And their doctors are going to look and say, well, I don't care. My bill is 3 times Medicare, and that's what you're going to pay. You know who's going to make up the difference? Not the insurance company, not the at-fault party. It's going to be you as the victim. So you're going to get victimized twice. You're going to get in an accident that's not your fault, and then you're going to get victimized again by paying more to the medical providers than you should have ever paid because of the wisdom of the legislature in passing what's called tort reform. I think the biggest thing with tort reform is it's going to do a couple things. It's going to change the court system because it's going to be so backed up. That's going to affect, I think, long-term for settlements. That's going to be a big effect with the tort reform, at least as we sort through it the next 2 or 3 years, because there's been so many cases filed. That's going to be one of the biggest effects. I think, to be fair, we got to learn how it's going to work as attorneys. And I think we, as someone that's been practicing for 25 years, I'm ready to make that fight. I'm ready to take those constitutional challenges. I'm already working with attorneys locally, and we're coordinating on the right type of cases that we will make a constitutional challenge to various issues with this law. And that's important because there's potentially ways to change law, and there are issues with that law, but it has to be the right scenario. It has to be the right case to be taken up to the next level of the appellate courts. So we are identifying those cases. We are working with other attorneys on those type of cases. We will be coordinating all of our efforts at Beers and Gordon with other attorneys to see how it's working for them, see how it's working for them at trial. That's going to be one of the most important things. And when I talk about being involved beyond Beers and Gordon, beyond your law firm, being involved in Florida Justice Association, being involved in Central Florida Trial Lawyers Association, which we are heavily involved in both, and coordinating our efforts through those organizations, but more importantly, learning from the other attorneys on how they're doing it, if they get to trial before us on these issues, is going to be vitally important for the success of your own case.